Well, welcome everyone to the 14th webinar in the 2022 OSHA webinar series regarding process safety update, the latest with OSHA PSM and EPA RMP. Unfortunately, Eric was supposed to join us today. He had a last-minute conflict, but Mike and I are here. And we'll be presenting on RMP and PSM. And again, thanks for joining us. And we look forward to an interesting discussion today. There's been a lot of progress sort of on the PSM and RMP forefront. So looking forward to this webinar for a while now. But before we get into it, just quick introductions. I'll let Micah introduce himself, and then I'll just give my quick background, and then we'll get into it.
Hey there, everyone. Thank you for joining us. My name is Micah Smith. I'm a partner at CONMOSIL's workplace safety practice, and I lead most of our process safety efforts. I've been doing this for about 15 years, handling litigation, enforcement actions, investigations, the run of matters like that. And so I'm excited to be presenting on process safety today with Beta. So I'll hand it back to Beta to introduce herself.
Great, thanks so much, Micah. So hi all, my name is Beta Carey. I'm an associate at CONMOSIL Carey in the OSHA Workplace Safety Practice Group and a former attorney investigator of the U.S. Chemical Safety Board, or CSB. And while I was at the CSB, one of the larger roles I played was, drafting the regulatory sections of the investigation reports. And, as you can imagine, RMP and PSM were definitely topics that came up a lot and, still come up a lot. As an associate, I represent employers in the full range of matters regarding the OSHA Act and handle sort of full range of litigation related to contesting OSHA citations. And I also help manage inspections initiated by federal, state, and local regulators. So on our agenda today, we have, of course, EPA and OSHA, their rulemaking efforts. We've seen a lot of progress in the last few months, even on this front. Then we'll do a quick, CSB background and updates. That's something I always enjoy, just coming from the agency. And then we do have sort of a special segment, and we have a special guest to present on Cal OSHA, the Cal OSHA PSM update. Obviously, Cal OSHA has a very unique PSM regulation, so we wanted to make sure to cover that in this program as well. So with that, I will hand it back to Micah to discuss the EPA RMP rulemaking.
All right, thanks, Beta. So I'll give you all the overview of where things stand with EPA and OSHA and the rulemaking. Unlike other years where we've done this annual PSM webinar and focused some on enforcement actions or on recent big cases, this year is all about rulemaking. That's been the theme beginning in the summer and continuing through the current month. And so we'll focus on that. I'll take you through the RMP and PSM rulemakings, and then I'll hand it back to Beta to close out the webinar with Clyde. All right, so we're going to assume that everyone here has has a decent amount of background in terms of these process safety regulations, and we just wanted to give you a rundown of where things stand. So I enjoy giving the history of the RMP rulemaking from 2016 through 17, 18, 19 with all the back and forth. We won't belabor that point here. I assume that everyone knows that, but we've arrived here in year 2 of the Biden administration, and this administration with EPA has really picked up where the Obama administration left off, and they have again moved forward with RMP rulemaking, looking to expand the rule, make some changes. I think a lot of what you see here may look familiar if you remember what was going on back 5 or 6 years ago with the last rulemaking. But what we're going to do here is run through some of the major topics in the rulemaking, talk a little bit about what are some of the industry concerns, talk about potential impacts of those changes. We'll run through that here. Interestingly, Beta, could you go back one more slide? I'm sorry. Interestingly, when we look at the purpose of this rule, EPA, talks generally about this and says, we're looking to strengthen the existing program and add new safeguards that haven't been addressed in prior RMP rules. I almost feel like they're making an inside joke because many or most of the items here have showed up in previous rulemaking or in previous rules that are no longer around. So I'm not quite sure whether that's an inside joke or if they're just suggesting that these things don't exist currently. The rulemaking here started off earlier this summer. EPA issued the proposed. Then there were public hearings in September, and then comments were due at the end of October. Listed here are the major topics that we're going to talk about. If you look here on the left side, what you'll notice, and if you haven't picked up on this yet, we'll talk about it a little bit. A lot of the changes that are made or proposed here in the RMP rule focus on the early parts of a PSM program. So I tend to think of the build-up of a PSM program. You create it by having some number of programs, elements created, but you really get into the meat of it when you start doing hazard assessments, you start compiling process safety information, and you build up what you need in order to implement a PSM program. Well, in the left column here, you see three things that are going to show up generally in the PHA phase of things, and a facility siting comes back around, not necessarily tracked to a specific PHA. But on the left side here, these issues come up at the PHA phase. On the right side, another major focus, you can see everything that's related to things like emergency response, community notification. So we've got that divergence there. EPA spends a lot of time thinking about, all right, what goes wrong, or what's going to happen when things go wrong? Are communities prepared for responding to incidents and things like that? Do communities have the right information? So those are the biggest pieces of the RMP proposals here. In the middle, you see a few others, and we've highlighted a couple here. We've got some changes to employee participation, some changes to to compliance audits generally, focusing on the third-party aspect there, and then using root cause analyses for incident investigations. So what I find to be interesting at an initial level about these proposals is that it's not necessarily a deep dive and rewrite of the entire standard. You really see EPA focusing on these specific elements. So on the PHA side of things, emergency response, and then really looking at incident investigations and audits. So moving to the next slide.
All right, I lost my audio for a second. Can you all hear me?
I can hear you, Micah.
All right, fantastic. Sorry, I phased out there for a second. I don't know what happened. All right, moving to the next slide. We're going to focus on some of the PHA items here. So the first thing that is brought up here focuses on natural hazards and power loss. So in everything that EPA has started doing recently, there's been a big change. They're focusing on climate change, right? That's been a big theme. It showed up for the Biden administration when in most of the rules that they're making. All right, so this is the best example of how climate change is coming back into the into the rule. So under this element, EPA is asking facilities to take a look in their PHAs at natural hazards. So one of the biggest impetuses here is going to be things like Hurricane Harvey and the incident that happened at Arkema. There was a natural event, a hurricane that resulted in flooding, and there were pretty significant complications as a result of that really weren't foreseen, because things happened that had never happened before. And so the idea here is that, the world is changing at some level. We are now acknowledging some hazards, or at least we're seeing hazards that we didn't think were possible before. And EPA is saying, all right, we need folks to start looking at these things and making sure you've taken them into account. Now, I think if we learned anything from Hurricane Harvey and the Arkema incident, it's that, I think there's certainly some of that needs to be done. Folks need to know if they are located in floodplains and things along those lines. What we and of course, loss of power, with storms and power outages, the significant ice storm in 2021. I know a lot of facilities had problems back in February of 2021. Some of that was related to power outages, some of it was related to freezing, but those are the kinds of things that are meant to be addressed here. I think a lot of the concerns that we have related to this come down to a concern about whether facilities are going to be able to know what it is that EPA expects them to do on these issues. I hearken back to OSHA's original PSM NEP, and there were a few questions in here that kind of struck us in a similar way. So they had in the questionnaire there, have the PHAs or has facility siting, has it addressed issues related to flooding? They were always asking questions about trains, the potential of train derailment. I saw a few inspections where they got into, there's an airport 4 miles away. Have you evaluated what you do in the event of a plane crash and things along those lines? So while I think we understand the purpose of this, and I think we can all recognize that there is a legitimate reason for doing this, we still have some concerns about how vague it is. How will the facility know whether they've addressed this sufficiently that they won't be second guessed? You can imagine that if you experience a flood, unlike one that you've ever experienced before, and something bad happens, you might see an investigation, you might see fines related to that. And I know that that's a concern related to that. I think we'll all be looking to see how EPA, assuming they keep this in the final rule, how they frame it, how they explain it, and see whether there's enough specific there that we think that folks can comply when making the best efforts. The other part of this element that we wanted to flag here, and you see it in the second bullet here, and this is a bullet that you see copied on this slide, and you'll see it on other slides. The other issue that's raised here is that EPA has proposed that anytime there is a recommendation related to a hazard evaluation for natural hazards or power loss, if it's rejected by the management team, that a justification for the rejection be included in the risk management plan. Now, I'm assuming a lot of you participate in your 5-year renewals of your RMPs. And I think if you've been around long enough to know, what are the extent of PHA recommendations, how many different PHAs you have at your facility. If you're looking at a refinery, you may have dozens of different units and different PHAs that come around every 5 years. You can imagine the level of work that may be required to include in your updated risk management plan a justification for every one that you didn't complete. And if we're being honest, I think there are times, and there are some PHA teams where they envision their role as being kind of issue spotters and sort of blue sky thinkers. They're sitting down, they're trying to figure out what could happen, and they're just having a nice brainstorming session. And I think that is a great thing that they do. They can come up with some potential problems that haven't ever been identified before. At the same time, in those sessions, you're somewhat prone to having some bad ideas or some irrelevant things. I've certainly seen cases where a PHA team identified something as a hazard, and it wasn't because there was already a safeguard in place, or that they lacked a certain amount of information related to the chemicals in the process or something. They just didn't understand why it couldn't be a hazard. I think one of the things I'm concerned at with this particular provision is that we may need to include in a risk management plan justification rejection for, you know, a half dozen recommendations that were, you know, poorly founded, that were, had the team had a little more knowledge, had they had a little more time to spend on it and do some digging on their own, they could have identified that, oh, that's not necessary. This isn't actually a concern. So, you know, I think some of the comments that were submitted to this rule really focused on the potential burden of paperwork on this one and how that could really be a problem for companies. And I think that's something that we would agree with. And, you know, how EPA frames this requirement in the final rule will really tell whether that's a major obstacle to compliance or not. Moving on to the second one, the EPA has included a proposed change to facility siting. What we're looking at here really focuses on changes to the facility. And so I wanted to get the exact language here. I'm sorry, I'm struggling to get it right now in front of me. But one of the things that they talk about is they talk about siting inside the facility. Where are certain pieces of equipment located? Are you located next to other facilities? If you are next to other facilities, you know, do you have certain equipment close to other certain equipment across a fence line? And so this is a way, I think it's something that everyone has acknowledged is a potential concern that previously there was no regulatory framework to address. And so, you know, we can understand why this could come up. Of course, we always have concerns. And one of those concerns here is, how does this get administered? How we can certainly evaluate facility siting, but right now, as it stands, there's no specific guidance on as we evaluate it. Is there a certain risk level that we're supposed to reduce to? What are we supposed to do? We've identified the potential for interactions between our facility and the facility across the fence line. Well, what do we do about that? Who has an obligation to build a wall? Who has an obligation to reduce inventory? I mean, certainly you could end up in a staring contest across a fence line saying, hey, you all need to run less rate. You need to lower your pressures over there so it's less, potential incident is less serious. But so there's a lot of open questions about what facilities are going to need to do as they evaluate the facility siting here. And of course, just like I flagged earlier, EPA has proposed that the requirement that you justify in your risk management plan anytime that you reject a recommendation from a facility siting. I presume this is facility siting study, so that raises other questions about, if you use an outside vendor, as many folks do, to evaluate facility siting, are you then required to respond to their recommendations in your risk management plan? Or is this maybe cabined more only for your own internal PHAs as you evaluate facility siting? That's an open question, but it's one that's kind of giving us a lot of concern here. Moving to the next issue, I won't spend a lot of time on this one, the safer technologies and alternatives analysis. The reason for that is that it's a repeat from the 2016 RMP amendments. So I think everyone generally knows what this is if you've been around and you remember that process. There is a there are a lot of concerns about this because and I think our primary concern is that safer technologies and alternatives analysis is a really fantastic idea for new facilities. If you are putting in a new process and you are starting from scratch, it makes a ton of sense that you ask some questions. You think about, should we change chemicals and things like that. Some of the major concerns here are related to the fact that this ties into your PHAs. And so there are, if you're an existing facility, some facilities have existed for a dozen years, some closer to 100, maybe more than 100 years, that you may be using certain technology. There have been previous requirements to make sure that it is safe and that it even if it doesn't comply with current RAGA that it is safe to operate. But even with that, you know, are we looking to make sure that these facilities are coming up to 2022 technology and going forward? And then further, you know, if somebody, I don't know if everybody saw the news, I think it was yesterday, that somebody made a massive breakthrough in nuclear fusion, something that scientists have been pursuing for a very long time, and so it's potentially groundbreaking, not for the process safety industries, but it signals the fact that there can be significant scientific advancements. There may be something developed that could be game changing, but that could also be incredibly expensive if you have to shut down an existing process and start a new one. And we're concerned about how this particular provision gets rolled out and how folks are going to have to deal with it. And yet again, the fact that there's the proposed requirement here to include your justification in your risk management plan if you don't adopt the safer technologies and alternatives analysis recommendations. So that's one that we're tracking. Leaving behind the PHA focused issues, we switch over to root cause analysis. This is also a retread from the 2016 RMP amendments, and the proposed requirement here is to require certain facilities to do a root cause analysis. You know, I think if you read some of the comments in the rulemaking, you'll see that there's some concern about whether this is always the right approach. I think there are certainly times when, well, I think we can all agree that any incident you ought to determine the cause, but whether calling it a root cause analysis prevents you from using certain investigation techniques, or are you anchored to a particular one that may or may not be useful in different incidents? We know that some incidents are very equipment focused. Some of them were caused by human factors. And so there may be issues, there may be times when using an alternative method may be more appropriate. And so I think we have concerns about whether this, you know, having this very prescriptive requirement is appropriate in the RMP. So, all right, next issues here, third-party compliance audits. The proposal here is to require, under certain conditions, for a facility to only use a third party to do a compliance audit. So this is going to be for any facility if they've had 2 RMP reportable accidents within 5 years, or if you are a Program 3 process in the refining or chemical manufacturing codes within a mile of another RMP facility under those codes, and you only have 1 accident, RMP reportable accident, then that's going to trigger. This is, you know, I think this is potentially problematic, and this is a concern that was raised 6 years ago during the RMP amendments, that at this time, we're not exactly sure whether there are sufficient third-party auditors out there. Probably there are. I know many facilities, we've facilitated them using third-party auditors, but there's some question about availability and pricing. If these auditors really see significantly increased demand, are facilities going to be forced to pay a lot more for them just on the basic laws of supply and demand? The other concern here is it gets closer to something that is more legally focused. And it's this idea that if you are using a third-party compliance, a third-party auditor, they have a certain interpretation of the rule. And I don't know if we have any of our third-party auditors on this webinar, but if they are there, I know that they're shaking their head as I talk, knowing how often we debate about what exactly do the rules require. And they may have a different opinion of that. They often have a different opinion of that than I do, and we have to hash those kinds of things out. Well, you know, if you are putting in the hands of a third-party auditor a decision about whether a particular system that you're using is compliant, if you've got gaps in compliance, you know, there's a question about whether EPA is delegating the interpretation of some of their rules to a third party, someone who's not the government. And while I love all of our third-party auditors, sometimes they have ideas that I've never heard about before. And, it raises an interesting fair notice question about, if we don't know that this particular auditor thinks this is the way it ought to be done, how are we supposed to know that we were supposed to be doing it before they showed up? And if we'd hired a different auditor, maybe they wouldn't have thought that. So this is only compounded by the fact that EPA has proposed that you have to include a justification for any rejected audit recommendations. So adding together that rejection justification along with the third-party auditors is something that's concerning, and we're not quite sure how it'll shake out as it gets administered. All right, the next element is employee participation. There's a couple specific issues here. I think our primary concern about this one, it's interesting because I've grown up as an OSHA practitioner. Employee participation is something that is really important for OSHA, because the OSHA rules are designed to protect employees. That's the focus. And historically, EPA's rules have been very much focused on protecting the public, protecting the environment. Adding an employee participation element, it's a little bit jarring because it changes the focus somewhat and brings in employee issues and brings in concerns about, all right, is EPA going to take a strong position on how facilities interact with their unions, with their employees individually? So it's interesting. I certainly understand the impetus here, because employees who are out in the facility, who are operating PSM and RMP covered equipment, they are the front line to preventing releases. So it's important that there are elements that are there and that their input is taken into account. But it's interesting to see EPA regulate this one, so that's one reason why this one kind of struck us as an odd requirement as it came across. Moving along, we've got the last three here, and as I noted earlier, these really focus on emergency response and interactions with the community. I don't think we'll go into much detail here, but there is a focus on interactions with local responders that you're going to be relying on, making sure that you do sufficient exercises, that you are working with them, you're providing notification. There are concerns about what do you do if you have local responders who are maybe they're overtasked and they're not available as often as you would like. They can't, they're not staffed well enough to send people in. Certainly as a private company, you don't have any ability to affect government local responders, and especially you can lobby your local representatives, but you have certain limitations when it comes to your interactions with them, and you can't force them to do anything. So we're a little bit concerned about how those interactions will go. Will EPA say that local responders have some kind of a veto if they say they're unable or unwilling to provide certain types of support, unable or unwilling to do exercises? What's the reaction going to be, and how much will be enough as these facilities go through implementing these things? Last thing here is the enhanced information availability. EPA is pushing for facilities to make more information available to their communities. This fits into kind of the environmental justice focus that EPA has taken over the past few years on a lot of different issues. And there's the longstanding concern, and you see it in many different regulations, embodied probably most particularly in the CFATS reg from Homeland Security, that providing information to communities is important. But as you share information with a wider audience, you don't quite know who's going to get their hands on it. And so there are some concerns about what information is being made available, and whether there are significant security and safety risks associated with that. So that's an issue we're going to be watching to see how EPA addresses as this rulemaking goes forward. And with that, that's the end of our discussion of RMP. Those are the major issues that we're watching. Those are the main ones that are included. I think at this point, we don't have a clear idea of EPA's timeline moving forward. Um, I think you'd be crazy to bet against them trying to get this finished before a presidential election in 2 years. We all know how changes in administration can alter agencies' ability to push forward with rules that they have in process. So I think we're all but certain that EPA will be moving this forward fairly quickly, but fairly quickly in the regulatory scheme of things can mean anything from a few months to a couple of years. So keep your eye on this, and we'll see what move EPA takes next. And assuming that they issue a final rule, which of these provisions make it into the final rule and which of them are significantly changed. So we'll be watching that. With that, we'll move on to OSHA's PSM rulemaking. This one we'll spend a little less time on because it is much earlier in the process. So we, again, not to belabor the details of previous rulemakings, but after the West Texas incident in, was it 2013 or 14, we had an executive order that directed OSHA and EPA to move forward with updating the PSM and RMP rules. EPA got theirs moved forward and submitted made final some RMP amendments in 2016. OSHA didn't get updates to the PSM rule across the finish line during the Obama administration. So there was a fair amount of work done there. There was request for information. They made it through the small business review process. But at the end of the day, we never saw final regulatory text. There was never any proposed text, so we didn't know exactly where they landed. They took in a lot of information. Comments were submitted from a lot of different folks, but we didn't have any idea where they landed. So after going dark for 4 or 5 years on the rulemaking front, OSHA popped up again. We knew they were thinking about it because they were showing up in community stakeholder meetings that EPA was having last year, and we knew OSHA was present, that they were paying attention, that they were coordinating. So we knew something was coming, but they popped up a little bit unexpectedly this summer, or maybe it was even August. I think it was late summer when they issued a request for information and a notice that they were having a stakeholder meeting. At that time, in the request for information, they signaled a fair number of issues that they were considering addressing in an updated PSM rule, but didn't signal, didn't provide any proposed text, didn't give a lot of direction, and really echoed a lot of the provisions or a lot of the issues that they had raised in the 2014 RFI. So there was a virtual stakeholder meeting held in October. Public comments were due in November, and so we know they have some information. We know they intend to move forward, and the question really is, what do they do? Many times an agency will, following an RFI, they will take all of the information, all the comments, and evaluate the rule they were considering proposing, and maybe try to finalize some proposed regulatory text. They may continue to do some research, maybe work with stakeholders. They could go back into the small business review process if they want to. We can be certain they've made it very clear that they intend to continue to coordinate with EPA as EPA moves forward with RMP. And so that definitely puts a certain amount of pressure on OSHA to go ahead and move forward, or to at least follow in EPA's footsteps if EPA gets their rule out first. So that's kind of the future. That's the path forward. With that, we've included in the slides here, we won't go through all of these, but some of the major issues that have been flagged. For those who are well versed in these issues, you'll see the first bullet here goes right at the what we call the mirror exemption related to atmospheric storage tanks. The mirror case, I believe it was in '97, where just a few years after the original PSM standard was issued, a judge said, hey, you can't, your exemption for atmospheric storage tanks doesn't take into account whether these things are interconnected. So even though OSHA tried to enforce against an employer who had their storage tank interconnected to a process, the court said, no, your exemption doesn't allow that. They're outside the standard. And OSHA has long wanted to make some changes there. So they've signaled that they are considering clarifying the exemption. I think the use of the word clarify is interesting and perhaps understated in terms of what they want to do. I'll try to restrain my skepticism and hope that they'll find a way to do something that is actually clarifying instead of changing an exemption that industries have really come to rely on. OSHA has talked about expanding PSM rule to industries or industry sectors that are not currently covered. So that includes oil and gas production facilities. They've also talked about expanding the coverage to really loop in reactive chemical hazards much better. They signaled that they may update the list of covered chemicals that are listed in Appendix A of the PSM standard. And of course, they may include explosives and blastings in order to loop in some of those activities under related to explosives under the PSM standard. The last one that we want to cover here is defining the limits of a PSM covered process. We at CMC have a particular interest in this, having litigated the later appeals of the Wynnewood case, where there were arguments made about whether the PSM standard should extend to cover a steam boiler. At this point, the limits of a PSM covered process is a poorly defined issue from a legal standpoint. It very much relies on a patchwork of cases. And even though those are published and we have some idea what, where the courts stand on those, we don't have a Supreme Court case on that. And so, the Wynnewood case was decided by the 10th Circuit. Nominally, that has only limited precedential value in, let's say, Texas and Louisiana, where the 5th Circuit sits. So that's a bit of a gap. And then we also see that OSHA continues to issue citations that we think, at least at CMC, we think continues to move the goalposts in terms of what ought to be PSM covered. And so we've seen a couple of different enforcement actions where, let's say, interconnected vessels across a property boundary. OSHA thought that didn't matter. We think that the existing framework, the interpretations in the cases say that's not, they can't do that. But they're proceeding in an enforcement action. So while I always worry anytime I see that OSHA is potentially changing their stance on where the limits of a PSM covered process are, I do think that more clarity could be useful, at least in terms of helping regulated industry understand where OSHA thinks they ought to be applying PSM. So those are all focused on scope changes. There are a handful of different proposed, or at least potential changes to requirements of the standard. There's a proposal to include definitions of RAGAGAP and of critical equipment. If you know the litigation history here, that there's been a lot of back and forth on that. And so that could be a particularly interesting one to see where they go with that. I'm trying to skip down through this. The issues related to process information are very interesting in that they're proposing to require continuous updating of collected information. So, rather than every 5 years as you're preparing for your PHA, making sure that you're updated, as some of the cases have suggested that would be appropriate. They may change it so that at all times, every piece of process safety information must be accurate. I'd say that's not particularly different from the current enforcement activities of the agency, but at least on paper, that's not the current requirement. There is, similar to what we saw for the RMP, they're considering a requirement for formally resolving PHA recommendations that are rejected. So some sort of official documentation that is more extensive than currently. Right now, it's fairly simply stated you can reject these recommendations, and I don't think that there's a national standard or really even a common practice for how you do that, how you document it. Similar also to some of the EPA provisions, we've got the safer technology alternatives analysis as a potential thing there, and then also consideration of natural disasters, extreme temperatures, just like we saw for RMP. And then the last few issues here, let's see if there's anything extra to address. All right, some that I think are particularly interesting relate to mechanical integrity. So perhaps changing the definitions under J1 of what is equipment covered by the standard to explicitly include critical equipment. I think for a very long time, OSHA has taken the position that critical equipment has to be covered, but they've not had a very good legal basis to do that, even though they've won a few cases along those lines. The potential change here to better explain equipment deficiencies, that really goes to the heart of the case that was litigated a couple of years ago, the BP Husky case, which focused on a lot of release systems and whether the company had adequately taken adequate interim steps to make sure that deficient equipment was operating safely. There were some arguments about whether the equipment was deficient at all. That could get tricky as OSHA, if OSHA pursues changes there. And then there's a run of emergency response related things, potential to require third-party compliance audits. So you're seeing a lot of mirrors to the RMP proposed rule. The final one is interesting and would potentially be a significant new burden for some companies. The requirement to develop a specific written procedure for every part of the PSM standard and to have identified ahead of time what are the relevant records. At this point, I know sometimes I go into facilities and I say, okay, where is your process safety information? And sometimes during an inspection, OSHA will say, give us your process safety information for this particular unit. And there will be times where people are looking at each other, scratching their head and saying, okay, where is our design basis? Where is that? Do we have all that? And so that could be an interesting requirement, and it could in some ways mirror Cal OSHA's injury and illness prevention program, where they're actually requiring you to document every aspect of your safety program, just applying it to PSM rule. That could be particularly interesting and could be challenging for companies to implement. It might be beneficial in the long term, but I could see it being a big challenge. I believe with that, we're at the end of the issues. As I said before, with RMP, we're not exactly sure what comes next. There's a lot of different options. I'm less convinced that OSHA will get this one across the goal line than I am that the EPA will get the RMP rule across the goal line. I think OSHA wants to get it done, but there is, because they haven't issued a proposed rule yet, there's a lot farther to go. And so if we see OSHA taking steps to get a proposed rule out in the next few months, I think we'll know that they intend to get that done in the next year or two. Barring that, this could drag out for quite a bit longer. So we'll be keeping an eye on that. So with that, I'll turn it back over to Beta to keep talking about CSB.
Great, thanks, Micah. And I do see that there are a couple questions in the chat. One related to third-party auditors. If there's any guidance on what qualifications a third-party auditor will need to have, how independent will they need to be? For example, if the company has a business relationship with a third party, does that rule them out as not being independent? Micah, any thoughts on that?
It's a great question. The only time I've seen this happen is where we've seen an agency take a position on this is when we have big settlement agreements related to incidents or things like that. And so typically EPA will do this, and I think OSHA does sometimes as well. They will issue they will include in the settlement agreement a specific independence clause and say they have to be this far removed. They can't have worked for the company within the last X number of years. So far, I don't think I've seen any additional guidance on that to see how that would look in a rule as opposed to a specific settlement agreement. I mean, I think the question related to, okay, do we have a sort of a regular contractor as a third party I think you could also ask the question of, if you are a multi-site facility, would it be appropriate to consider an auditor from a different facility, still an employee of the company? Would that be appropriate? They're arguably a third party. They're not from that site, and I know many corporations with multiple sites do that already. There's some question about whether that would be appropriate. I suspect not. I think the questions will probably hinge on how many times can you use the same consultant? Can you use the same consultant to audit all your facilities, or do you have to change? I mean, I can see some benefits and disadvantages going both ways on that, based on developing relationships and getting consistency with your auditors. But we really don't have a good idea yet what the agency will do. If it's like settlement agreements, they will look for a lot of independence, but I don't know if they can do that in a rule in the same way.
Right. That's very helpful. Thanks, Micah. And I know there are some more questions trickling in. I just want to make sure we can get to the end of our presentation. Tristan, I'm glad you could join us. I know you were asking about clarifying the scope for retail facilities. I know that there was a lot of back and forth after the EO was issued on the retail facilities exemption. There was sort of that, the 50% rule that got sort of pulled back, and OSHA went back to sort of their original preamble language about gas stations. But again, I just want to make sure we have enough time to get through the rest of our presentation. So we'll be sure to follow up with you all as questions trickle in. So with that, moving on to the CSB, I'll go through this quickly, but we always do a little update on the CSB, which I can always appreciate. And it has been a pretty busy 2022 for the agency. Then we'll move on to speak with Clyde Trombettas, the former program manager for the PSM unit at Cal OSHA, who has some, key insight into the rulemakings, having interfaced with the agencies. So, starting out with board members on a CSB update, as you might recall, during the last administration, the CSB was on this targeted list of agencies up for elimination. So there are not that many board member nominees, but we did get one, former chair Lemos. But what happened was, through resignations in terms of prior board members expiring, their terms expire after 5 years. We ended up with this quorum of one, basically one board member who was also the chair of the CSB. And that had never happened before. When I was at the CSB, 4 of the 5 seats were filled for the most part. There had been 2 board members in the past at one time, but never one. And the enabling statute didn't really address that situation either. So it was kind of new territory. And that lasted for quite a while, as you can see, from May 2021 to February 2022. But President Biden did make a number of nominations, and by February 2022, we got 2 new board members to join the board. That's Steve Owens, and with experience from the EPA, and Sylvia Johnson, with background as an occupational epidemiologist. So it was 3 of 5 seats filled, at least for a little while, but then we had the chair actually resign in June, and it went back to 2. So when the chair resigned, board member Owens became interim executive authority, and that is where things currently stand. So on November 17th, just about a month ago, the Senate's Committee on Environment and Public Works Chemical Safety Subcommittee did hold a hearing where interim executive authority Owens was nominated to become chair. And then we also had Catherine Sandoval, a law professor at UC Santa Clara, nominated to join the board. So the subcommittee didn't indicate when the full committee would hold a confirmation vote, but the Senate's last scheduled day before the session ends is December 21st. So if Owens and Sandoval aren't confirmed before this session ends, then the nomination process will start over again. So we'll see what happens. Another thing that came up during the hearing, and that's been sort of a concern for the agency for a while now, is the hiring of more investigators. I think interim executive authority Owens said that the agency currently has 10 field investigators and 3 supervisors, and that the goal is to get that up to at least 20. And I think that will certainly be helpful for the agency, since it is a very small agency. I used to describe it as a micro agency. And that's responsible for the whole country, right? We have certain CSB has nationwide coverage. So, it's hard for a small team to not only investigate, but also be responsible for, drafting reports at the same time. Alrighty, so that leads us to another concern that it looks like, the CSB is really tackling this year, and that is clearing out its backlog of open investigations. So if you were with us for our last PSM RMP webinar last year, you might remember us describing this, letter from Congress, where they, specifically addressed, among other things, the backlog of cases. And I think at that time, it was in May 2021, there were 20 open investigations, including one from 2016. So Congress did ask CSB to provide, a status of, where things stand and expected time frame to complete each open investigation. So here on the slide, we have the most current investigation closure plan. I think it's from October 2022. And the agency's been busy, right? Like you can see on the slide there, they've been issuing final reports. They've been releasing safety videos, which I think is a really helpful tool that the agency produces. They develop, and they've still been deploying too, right? There's I think that the September 26th incident in Ohio, the CSB deployed to that. So just this is just a slide to show that making a lot of progress here. Then moving on to our next slide. So another area, where we saw a lot of progress when the CSB was on its accidental release reporting rule. And as we've talked about in sort of previous webinars, this rule, the reporting rule, was issued on February 21st, 2020. That's when it was published in the Federal Register. Then it became effective 30 days later on March 21st, 2020. Then we had this 1-year grace period where the agency said it would not refer violations of the rule to EPA unless there was like a knowing failure to report. So that lasted until March 21st, 2021. So we've been in this post grace period, effective period of the rule for about 1 year and 9 months now. And just as a quick refresher, the rule requires owners and operators of stationary sources to report to the CSB within 8 hours any accidental release that results in a serious injury, substantial property damage, or a fatality, unless a report has already been made to the NRC, the National Response Center, in which case you must report within 30 minutes of that report. You have to give the CSB the NRC ID number. And of course, there are definitions to all these terms, right? Your substantial property damage is sort of triggered on, it's a $1 million threshold. Serious injury sort of tracks OSHA's definition. For a serious injury is an injury or illness that results in death or inpatient hospitalization, and that inpatient hospitalization sort of tracks OSHA. But the first piece, what we wanted to highlight here at least, was that the CSB released data on its reporting rule. And this first set of data, which is up on the screen, came out on May 20th, 2022. And it was updated a few months later in July. But this is something we think a lot of stakeholders were waiting for. We definitely had a lot of clients asking about, this data. And that was because in the preamble to the final rule, the agency did say it would, proactively disclose, subject to any statutory prohibitions, initial incident data at least once per year. So, given that the rule technically took effect March 2020, we might have expected data by March 2021, but, COVID-19, other priorities at the agency, and maybe, taking into account this 1-year grace period, we ended up getting this first set of data in May 2022. In any case, this is what some of the data looks like, and it's tracking from the period of April 10th, 2020 to May 9th, 2022. So we see that there are 150 incidents that were reported total. We have one full calendar year of data. That was in 2021. We had 80 incidents reported then. 24 incidents involved one or more fatalities, 90 involved one or more serious injuries, and 62 involved substantial property damage. And then in terms of location, we saw about a third of the incidents were either in Texas or Louisiana, with each having about 25 incidents. So and looking at the July one, there was an update to this data in July. I think there were about 10 more incidents that were included in that. But now now that CSB has this data, it's been released and it's been updated at least once now. Hopefully that's something we can come to rely on more in the future, is that it will be sort of regularly updated. A second piece of this related to the reporting rule is that the agency released guidance on its rule. And that was another thing, I think stakeholders were really hoping for, because again, the agency had alluded to it in the preamble to the final rule. So we did get this guidance document from the agency on September 1st of this year. And it came in this package of the 30-page guidance document, which is sort of a mix of general guidance up front, and then there are these FAQs, some of which are really, really specific. And we're just gonna, I'll just go through really quickly some key highlights from the general guidance and from the FAQs. So first, one sort of theme is that the CSB states it only has jurisdiction to investigate certain incidents, and that typically such releases will result from the production, processing, handling, or storage of chemical substances. And we get a lot of questions from clients who, are not typical CSB stakeholders. And, to that end, CSB provides us a few specific examples in its FAQs, like, it provides this example of like a paper product warehouse that experiences a fire because of an electrical wiring problem, or the malfunctioning of a diesel generator, which causes an accidental release of combustion products into the air. And CSB does say in such events, CSB would not deploy investigators because the incident was not associated, with the production, processing, handling, or storage of chemical substances. So CSB would not expect that warehouse owner to file or to report that accidental release. So again, this is just providing more information on the kinds of owners and operators that the agency is expected to get reports from. Another highlight from this general guidance is that the CSB states that complete information is the goal, but absolute perfection is not a requirement. So this rule allows for like this safe harbor of reporting within 30 days. And that goes, with this theme sort of that's throughout the guidance, which is that there's no sanction or enforcement action associated with reporting a release, which in retrospect did not have to be reported. But the CSB says the opposite is not true, right? If you were under an obligation to report it and you didn't, right, that could be something for CSB to refer to EPA for enforcement action. An EPA, and I'm sorry, CSB does say that just because you report a release does not necessarily mean CSB will deploy a team of investigators. Just one caveat to that is, and it's like with OSHA reporting, courtesy calls do sort of put you on the radar, right? So we do recommend just, as a firm, that you really do the analysis and make an informed decision about reporting. And this sort of flows into that first highlighted FAQ that we wanted to point out, is about the 8-hour reporting window. So if you don't know about a reportable outcome within that 8-hour period, you don't have to report within that window, obviously. But if you later obtain information within 30 days, then you must immediately report that upon finding it out to the agency. So note what that means is that there's not a requirement to update accidental release reports with information that only becomes available at the end of the 30-day safe harbor. So in that case, CSB will use its discretion to decide whether to conduct any follow-up with the facility after the 30-day window has passed, and facilities are expected to comply with any sort of requests for information from the CSB. So there are a lot of questions about this 8-hour reporting window that I think the agency tried to clarify in its guidance. And this is just our last slide on CSB before moving to Clyde, which I think will be, that will be a really exciting part of this presentation. So just a couple other questions here. This is a question we got a lot from clients, is how do we determine substantial property damage? So, as I just mentioned, there is this $1 million threshold. And I think the agency is pretty clear in its guidance that you do count just about everything. We got clients, asking us like, what do we include in our, substantial property damage calculation? And CSB does say it includes the full range of costs. So we have a few bullet points here about what that all means, but, loss of use, certainly. CSB even goes to say, damages to natural resources would be expected to be part of that calculation. Another question is, what types of substances are considered to be extremely hazardous substances? So, as part of the definition of accidental release, there's, one element of that is regulated substances, which tends to be a little bit more objective, but another part of this is extremely hazardous substances. And we always get this question like, could steam be an extremely hazardous substance? And I think CSB comes out pretty clearly that yes, the accidental release of water or air could meet the criteria of an extremely hazardous substance. They can be, EHSs can be in any form, liquid, solid, or gas. Obviously CSB has done a lot of work in the past with combustible dust, that's a solid. And what CSB really emphasizes is that what defines a substance as extremely hazardous is its demonstrated impact on people and the environment. So you're really looking for, did it cause serious injury, substantial property damage, or a fatality? So I know I went through that really quickly, but just want to make sure we do have time. I know we're going a little bit over, but now we're just going to transition to talking about updates to Cal OSHA's PSM standard with our special guest, Clyde Trombettas. Well, thank you very much, Clyde. As I mentioned, Clyde is recently retired from Cal OSHA as the agency's long-standing program manager for the process safety management unit. And thank you again, Clyde, for taking time out of your busy schedule to join us for our webinar.
Thank you for inviting me. I have like two caveats I have to say now. Now that I'm no longer with the division.
Of course.
I don't represent Cal OSHA anymore. As you know, I've retired as of September 30th. So any of my thoughts, opinions, or insights are those of my own. Also, I'd like to thank Phillips 66, my new employer, for allowing me to continue with a lot of my outreach work. And so I've been really appreciative of that. So thank you.
Absolutely, of course. Thank you, Clyde. So we'll just dive right into it then. We know that things have changed a lot, during Governor Newsom's administration. I think you had mentioned to us that, you were the last political appointee at Cal OSHA by former Governor Jerry Brown to leave Cal OSHA. So just, we just wanted to ask you about some of the big changes. We've heard there are an extraordinary number of vacancies at Cal OSHA right now, maybe as high as, 40%. What is happening in terms of staffing at the agency, and how is that affecting the PSM unit and its ability to sort of carry out its mission and conduct inspections?
So it's interesting, under the, Jerry Brown administration, we had back in 2012, Chevron Richmond Refinery had a huge event, and that promulgated a lot of rulemaking and regulatory changes. And there was a number of, obviously the PSM for refineries, was implemented in 2017. There was a labor code section that was implemented that required the unit to do turnaround inspections every year. There's also a health and safety code that required contractors to go through 20 hours of advanced safety training. There actually wasn't a labor code for the refinery unit, a minimum staffing requirement that was actually put in there. And one of the, I guess, the grateful things I am one of the grateful things I am about the Jerry Brown administration was that he allowed myself and Cal OSHA and DIR to really work with industry, as best we could on formulating these regulations, especially 5189.1. We went from 13, elements to 22 elements. Brand new sections, you were talking about damage mechanism reviews, hierarchy of hazard control, employee participation was expanded, management of organizational change, a lot of new sections. And it really required a lot of input from industry and from labor, and it really required dialogue. And Governor Brown's administration was very keen on that, very open to dialogue, and for the most part, very supportive of the industry. I don't know if the industry would quite agree with me on that, but he was actually very supportive of the industry, and knowing that these regulations had to be done was really receptive to open dialogue. New administration, different ideas, different thoughts come through. New administration, a lot of the Jerry Brown appointees had left. As you know, some of you know, OSHA reports to the Department of Industrial Relations. So a lot of us who were considered appointees or CEAs had left. I was the last to leave. One of the concerns that I had was that the new administration didn't really believe in dialogue with industry. And I'm not just saying the refining industry. I don't want to pick on the refining industry, but PSM regulates 1,500 facilities in the state of California, from chemical facilities, ammonia and refrigeration facilities, fertilizer facilities, distribution facilities, and a lot of that had changed under a lot of these industries were and those people have worked with me. I know I saw Amy Gaylord and Wayne Howard, so I tend to be a little candid sometimes in my discussions. But some of these industries have become more demonized, I guess you could say, in California. The outreach we were told, I was doing outreach with the state of Washington on their PSM regulation. A lot of that we were instructed to discontinue. I was able to get a lot of input in with EPA on their modifications to the risk management plan, but that was discontinued as of July. The division was told that, or the PSM unit was told, we could not provide any input on the new PSM regulation for the federal PSM regulation, and that led to, and then over on the staffing issues that you had mentioned, you would think, because the industry, the administration, the current administration has a different opinion about the industry, there'd be more inspections, but actually there's been less inspections. And there's been kind of a hiring freeze. They won't call it that for the PSM unit. When under the Brown administration, we went from 10 total staff to 42. Now they are down to 24. For the last 3 years, they've been almost cut in half, about 40%. And there's been no effort to staff the PSM unit. But actually, that's just a sub part of it, where actually Cal OSHA as a whole has been understaffed for about 30%. There has been an effort to try and staff up the Cal OSHA enforcement side, but there's when it comes to the safety professionals in California, or the safety career paths, state agencies aren't really where people are going to anymore. The benefit packages that were in place in my day aren't there anymore. The salaries haven't kept up. As with the Chemical Safety Board, a lot of the salaries and stuff haven't kept up. So it's really hard to retain. And I think one of the things you would ask me about was training, but I could kind of jump on that when we get to that point. So.
No, that's right where I was going to go next, Clyde, was into this sort of training. Do you feel like compliance officers are still getting the PSM training they need? It's PSM is specialized, right? It's not so much like others, safety and health topics. You really need a special level of knowledge and education. Do you feel like the compliance officers are still getting the training they need?
the short answer is no. So and it's a shame because, like I said, in the federal, in Fed OSHA, and actually my previous boss, Doug Parker, is now the assistant director of Fed OSHA. He, he understood that with the new regulation, has to come more training. One thing about, Fed OSHA inspectors, they've been, their regulation's been in place since '92. They've conducted really good training year after year. They conduct training for their staff that conduct PSM inspections. The new regulation for refineries came out in 2017. I think we started off with our staff with about, over 3 years, I want to say we probably conducted about 250 hours, 280 hours of training. That's all come to a stop. There hasn't been any training provided since the since COVID, just before COVID, and unfortunately, it's having a reflection on the inspections that's being conducted, because we do have people that have less than 5 years experience with the PSM unit, and the new regulation is only 5 years old, and there's also problems with the regulation. I can't go into detail because I have a non-disclosure agreement not to, but there's also a lawsuit that's out there that Western States Petroleum Association had filed back in 2018, and it talked about 4 elements of the PSM regulation, and those were the same 4 elements that PSM enforcement was having issues with. And there was, there was some dialogue about that through the standards board, which is a public forum, OSHA standards board. But even that had, I think the last meeting was last year, I believe, was our last public comment period about that. So, a lot of the training has been come to a standstill. And actually, one of the things that, just as a side note, when I came to Phillips here in Rodeo, my new supervisor had told me, oh, by the way, we got a Contra Costa County audit coming in, a 3-year audit coming in for Program 4. And what impressed me with them was that they had 6 to 8 compliance people here for 5 weeks, 8 hours a day, looking through every PSM document this facility has for the last 3 years. Cal OSHA has the same type of PQV inspections, but now you have only 3 people, who have some level of training, who are supposed to do the same quality and level of training as their Cal EPA counterparts. So it's been a little disheartening, I guess, to say on that part.
Imagine, yeah, absolutely. And just piggybacking off of that, Clyde, about the PQV. So these are the program quality verification inspections. They used to be sort of the primary way for the PSM unit, right, to get into facilities and evaluate sort of process safety compliance. Is that, it seems like that's not still the case. Can you touch on that a little bit more?
They're because of their staffing, they're not meeting their mandates. As an example, the PSM unit has a non-refinery side or a chemical side. Usually it's staffed with about 20 compliance officers, and they do 60 to 80 inspections a year of non-refinery, PSM inspections. This year, I think they've conducted 14. So, and there's only like 6 of them left, statewide. So it's, it has had a huge impact on the enforcement side, the PSM,
Sure thing. And I know you mentioned too that it seems like now it's mostly accident related, right? And the complaint base.
There's been a shift to do more accident and complaint based inspections. Also, there's talk of next year putting the PSM unit right now is kind of a standalone unit, reports to a deputy chief, and there's been a lot of talk now of pushing it back under Cal OSHA enforcement, which is really strictly the complaints and accident type inspections. The PSM unit for the last 3 years the staffing had been taken away from PSM inspections to conduct regular enforcement type inspections. So it's I see one of the things that's that bothers me is that with having a new regulation that's been out there for 5 years, with the issues of interpretation of the regulation, enforcement of the regulation, curbing outreach, curbing training, and curbing, working with sister agencies, I think is going to have a detrimental effect on it. So,
Yeah.
and I think in change it's going to hurt the industry as well to a degree. So,
Yeah. Gosh, well, I know that one thing you did before leaving Cal OSHA was commission the study on Regagap. And the report was published, I think, in this year. And I'm sorry, I didn't have your bio slide up.
Oh.
I thought I had it up this whole time. But yeah, we do have a couple slides here on the Regagap study. And I think some of the research questions for the study were, how has Regagap been interpreted and experienced, by industry, and how might industry and government interpretations of Regagap sort of, become better aligned? So, we have up here, I think, some of the findings and recommendations are from the report, and just wanted to ask you sort of the open-ended question of, what can you tell us about this, and what do you expect Cal OSHA will do with the study?
It's a, so I did ask there was an acting program manager. I talked to him earlier last week. And, actually the study has basically been shelved. And it's a shame, because one of, the reasons for developing the study and for having, the RAND Corporation, conduct the study for us was that there was the issue that in 2016, I think it was 2015, 2016, where Fed OSHA was trying to put out a clarification letter on Regagap about shoulds shall be used as shalls. And then there was issues about, there was a lawsuit dealing with pressure relief valves, dealing with Regagap. And the big thing for California was that under 5189.1, internal procedures were not considered Regagap. So, which is huge. I mean, it's a huge thing, for refineries in California. That was specifically for the PSM for refineries regulation, where internal standards are not considered Regagap. And if you use an internal standard, it has to be equal to or greater than an existing Regagap. And there was a lot of questions about that. I mean, well, what is a Regagap? And what would be, what would be equal to or greater than, an existing Regagap? What if a Regagap isn't available? I think, Mike was mentioning, some refineries are over 100 years old. I've seen, ammonia refrigeration system down in Tulare that it was built in 1909 and it is still active today. So what Regagaps do they use? So it's so that was kind of what what started the study, was to try and get a dialogue with industry, with refineries, and where can we come to some common ground, on what would you consider a Regagap, what is not considered a Regagap, are, some of the things from more, from other NGOs, was that, are API alerts considered Regagap? I used to put out reports. If there was like, the BP incident 205, I put out a report on flaring, also about high temperature hydrogen attack up in Anacortes in 2010. And were those studies considered Regagap or not? So there's a lot of those questions that, we were trying to get through and try to work through, and try to get some common ground about.
Right. Yeah. Definitely get some clarification around all that. Could be, very useful. So,
and if you notice the, federal EPA and Fed OSHA, if you notice, a lot of what their recommendations coming out actually stem from California's 5189 regulations, and also Cal EPA's Program 4, which, if you understand the RMP, which has the 3 programs, California has a 4th program, for refineries. And, as a state plan, you're not beholden to any of the federal OSHA decisions or the letters of interpretation. So in California, we determined that fertilizer industries and fertilizer distribution companies were part of PSM. There was a retail exemption given by the feds, and we decided that in California now that exemption does not affect the PSM regulation. So we worked with Western Plant Health to get them in under the PSM regulation. So and then on third-party audits, I'm not a really big fan of them. Matter of fact, my comments to to Cal EPA is that there's a two-edged sword, especially with third-party compliance audits and consultants, because they're not beholden to PSM inspections or CalOSHA inspections. So the question is, well, if a compliance auditor makes a recommendation and the refinery doesn't follow it, okay, or they make a poor recommendation and they follow it, okay, well, the auditor is really not, there's no consequence, there's no regulatory consequence for that. And, I've had some, I have had a number of issues where small PSM regulated facilities, had auditors come in, sold them programs, and they weren't necessarily written, what they're written on. So that was probably my biggest caution that I could make with Fed EPA was that, look, it's a two-edged sword with these compliance, with these third-party audits. It really is. And so I know Contra Costa County has the industrial safety ordinance, which can require third-party audits, but they've used them very restrictively. I think they've used, I would say, probably one in the last 10 years. So yeah, so it's something that I think is, federal EPA really needs to take a hard look at.
Sure. Yeah. And I know you've touched on this, Clyde, sort of where, some of the positions CalOSHA was taking in these rulemakings. I think, maybe the big question just want to kind of end off on is, can you give us a sense of what you anticipate, EPA and OSHA will do with their rulemakings, kind of magic ball this for us, what proposals or ideas do you think will end up in the final rules and, and what gets cut?
Yeah, the last I talked with, with federal EPA, which actually the biggest discussion we had is about on inherently safer technology. And, there's some history to that, which I think you mentioned about hydrofluoric acid. California, we have 2 refineries that deal with hydrofluoric acid. And there are these community groups that want to have the refineries eliminate the use of hydrofluoric acid. And like I've told them is that, as far as CalOSHA goes, we regulate the safe handling of chemicals. We don't have the authority to say you can't use them. And, we worked with, for one of the refineries, I worked with another refinery up in Washington to develop, more progressive safeguards for that facility. And so I was talking with, under our regulation, they're required to, under the PHA to consider other technologies, but they don't necessarily have to implement them. But in the PHA, they have to give, some kind of a reason why they're not. And a lot of them have done that. I think one of the 2 refineries, I just reviewed their PHA back in September, and they did talk about, 3 different technologies that were out there. They explained very well why, it would be a huge burden to the facility to try and incorporate those new technologies. And so with EPA, that was one of my things was well, what is an inherent safer technology? I know what inherently safer system is. We all know what inherently safer systems are, but what is an inherently safer technology? And how is it proven? We gave an example of integrated operating windows. That was that is a recommendation from API. We had talked with Chevron Richmond, and they incorporated, inherently safer technology, even though it was just a recommendation. So it's where does that? How are you going to write that language to say, well, inherent safer technology that's maybe a new technology hasn't been quite proven yet. How are you going to enforce that on a facility? So we had quite a bit of discussion on that. And there were some people within, DIR that, disagreed with me. They wanted to have, inherently, they thought, that EPA should have that language in there. I think it's kind of a slippery slope. And the federal PSM regulations, I think they pretty much kind of, threw everything at the wall. I'm really, my last statement to Doug Parker, we're talking about oil drilling and oil production. And I said, there is just no, it would be impossible for a small drilling company to comply with the PSM regulation, which is why California has petroleum safety orders. We have petroleum safety orders for drilling and production, and then one for refining and transportation. So it's outside of the PSM reg, but still has, health and safety guidelines, or regulations for that industry, which is, OSHA has, guidance documents, for, oil production. And then they use a general duty clause when it comes to, issuing citations. So I really hope they keep those, those two industries out of the PSM. Right?
Yeah, absolutely. And I think, yeah, it does seem, like Micah said, PSM does seem still very in the early stages. It kind of just seems like, still RFI, collecting information type of part of the rulemaking. So we'll see.
I don't see, anything really like, coming. I don't think anything coming, like I said, I think EPA has a better chance of getting this codified before the next election. I think that OSHA is probably going to move it to at least past the next election.
Right. So. Yeah. That'll be probably how it goes. I know EPA has got tons more resources, I think. So, so it's probably, contributing part of it too. But thank you very much, Clyde. This was incredibly helpful, incredibly useful. Thanks all for sticking with us. I know that we've gone over a little bit, but just to conclude, thanks again for joining us. And we've got our 2023 webinar series kind of geared up. This is just your first look at it. I think this is the first time anyone's seeing our sort of schedule. We're going to, do another one of these updates. As you can see, I think it's in November. Yes, in November. So hopefully you can join us there, and we'll have more news on probably on more on the RMP front than the PSM front, but still that we do expect some movement on both ends. So with that, I think that, yep, these are our blogs. Be sure to check them out. And yeah, we'll be sure to, any questions we didn't get to in the chat, we can we'll definitely try to follow up with you all. So thanks again all for joining us, and have a good rest of your days, and happy holidays. Thanks all. Bye.